They fined me $10,000 for having a home office. But I write the contracts that govern corporations for a living. I froze. Was this a prank? Or had my HOA truly lost its mind? The certified letter trembled in my hands as I read it again. Violation notice. Unauthorized commercial enterprise. Fine amount, $10,000, due within 30 days. My crime? Working at my desk in my own home, behind closed doors. My stomach knotted as I imagined what this would mean. $10,000 would devastate my savings. If I refused to pay, they could put a lien on my house, the home I'd worked 15 years to afford. All because someone reported seeing me through my window, typing on my laptop. I sat at the kitchen table until 2 a.m., laptop closed, lights off, just staring into the dark, wondering if I was really going to lose everything over a desk. The mortgage documents for this house were still in the filing cabinet. I'd helped draft similar ones for clients hundreds of times. Now those same legal instruments could be used to take my home away. For the first time in my legal career, I felt truly powerless. Was this what my clients felt when facing overwhelming odds? This hollow ache in the chest? This quiet desperation? I poured another whiskey, didn't drink it, just watched the amber liquid catch what little moonlight filtered through the blinds. Blinds I now realized I'd need to keep permanently closed if I wanted to work in peace. The irony wasn't lost on me. 20 years as a corporate attorney specializing in real estate law, and now I was facing financial penalty for sitting at a desk in my spare bedroom. No clients visited, no signage outside, no deliveries beyond the occasional Amazon package. Just me silently typing behind closed blinds. That night, I couldn't sleep. The audacity of it burned in my chest. I'd chosen Oakwood Estates specifically because it seemed reasonable compared to other communities. Had I been wrong? At 3 a.m., I sat bolt upright. This wasn't just about me. How many of my neighbors worked from home since the pandemic? How many were quietly living in fear of that same certified letter? Morning came, coffee in hand, I pulled up our state's Remote Work Protection Act, legislation I'd actually cited in a case last year. Section 3.1 specifically prevented HOAs from prohibiting quiet, non-disruptive work activities within private residences. They weren't just being unreasonable, they were breaking the law. But why target me? A quick walk around the neighborhood told the story. Nancy Miller ran a thriving nail salon from her garage, clients coming and going all day. The Johnsons gave piano lessons every afternoon, the sound of scales echoing down the street. And board member Frank Wilson's wife operated an online crafting business with daily UPS pickups and deliveries. None of them had received violation notices. I smelled selective enforcement. But I needed proof. As a homeowner, I had the legal right to review all HOA documents. I requested everything: board meeting minutes, financial reports, covenant amendments. What I discovered made my blood boil. The board had recently hired a management company owned by HOA president Richard Keller's brother-in-law. Their contract awarded them 30% of all fines collected, $10,000, 30%. The math wasn't subtle. But that wasn't all. The rule against home offices had been added in an amendment last year. Our bylaws required a 2/3 majority vote from all homeowners for amendments. The meeting minutes showed only the board had voted. 7 people out of 218 households. The amendment wasn't just unfair, it was invalid. I photographed everything, made copies, organized evidence. Then I crafted my response, not an emotional plea, but a precise legal document citing the HOA's failure to follow amendment procedures, documented examples of selective enforcement, the glaring conflict of interest in fine structures. I hand-delivered copies to each board member's home, then requested a formal hearing. Word spread quickly. By the time the hearing date arrived, my phone was buzzing with texts from neighbors facing similar threats. They're saying I can't do video calls from home. I got a warning for having a work laptop on my porch. Will they come after teachers next? The fear was real and spreading. Tuesday evening, the community center was packed, standing room only. I arrived in my courtroom suit, evidence organized in a leather portfolio. Richard Keller's face fell when he saw me. "Mr. Harrison," he nodded stiffly. "We didn't expect you to actually attend." "I wouldn't miss it," I replied, my voice steady despite my racing heart. Richard immediately tried moving my case to executive session behind closed doors. "I believe I'm entitled to a public hearing under Section 12.4 of the bylaws," I countered. "Unless there's a specific provision you're citing." The HOA attorney shuffled through papers, looking increasingly uncomfortable. "The hearing will remain open," Richard finally conceded. The room fell silent as he outlined my supposed violation, working from home, observed through my window. When my turn came, I approached the front, making eye contact with each board member. "Thank you for this opportunity," I began. "I'll be brief." I laid out my case methodically. The Remote Work Protection Act, the improperly enacted amendment, the 17 other home-based workers facing no penalties. With each point, I placed a document on the table, clean, precise, devastating. The HOA attorney's eyes widened as he scanned the papers, whispered urgently to Richard. "I saved the conflict of interest for last. And finally," I said, my voice dropping to ensure everyone leaned forward, "I find it troubling that the management company receives 30% of all fines collected, a company owned by President Keller's brother-in-law." Gasps rippled through the crowd. "Given these concerns, I've prepared legal filings to contest this matter," I concluded, pulling out my draft complaint. "As a courtesy, I wanted to give the board an opportunity to reconsider before I file tomorrow morning." "Legal filings?" The HOA attorney finally spoke. "On what grounds?" "I've outlined the statutory violations, procedural errors, selective enforcement, and conflicts of interest," I replied calmly. "I've also named individual board members as defendants, as permitted under the Act's anti-retaliation provisions." Their faces drained of color. The board requested a recess. 20 minutes stretched to 30. Neighbors approached, sharing their own stories in hushed tones. A medical transcriptionist who'd been warned. A graphic designer afraid to put up a desk. A teacher conducting online classes with paper over her windows. When the board returned, Richard's confident smirk was gone. After reviewing Mr. Harrison's documentation, he announced tightly, "The board has voted to dismiss the violation notice and associated fine." A cheer erupted from the back of the room. "Additionally," he continued, looking physically pained, "we will form a committee to update our covenants to comply with state law." Victory. Without filing a single court document. The aftermath was swift. Neighbors who'd been silently suffering came forward with their stories. The management company's contract was terminated after a financial audit, and at the next election, 3 work-from-home residents joined the board. The most unexpected outcome: the new board asked me to become their legal counsel. I accepted, with one non-negotiable condition: I would sometimes be working from home. 3 years later, Oakwood Estates has become a model community for the modern work era. Our updated covenant specifically allows home offices with reasonable guidelines that protect everyone's interests. As for Richard Keller, last I heard, he moved to a neighborhood without an HOA. The pandemic changed how millions of Americans work. Your home isn't just where you live, it's where you create, contribute, and earn your living. If you work from home, you have rights, even if your HOA doesn't want you to know that. They tried to fine me $10,000 for sitting at a desk in my own home. Now, I rewrite the very rules they tried to use against me.